Is Bhairav, Acharya. Thank you for having me. It's nice to be here. I'm going to make today a very, quite unlike what I read, I'm going to make a very nuts and bolts legal argument for privacy protection through executive action. And there's a reason I want to do this, which I'll come to. But just before that, I wanted to, I didn't get a chance to talk to you, so I just want to differ respectfully with my colleague, Mr. Bhairav, on the Black Friday matter. Black Friday went through 3 rounds of censorship before the case began, including a certificate from the censor board. And the principle is that once a film gets cleared by the censor board, it should not be struck down elsewhere, whether in the open street protest or outside. That principle should equally apply to speech that is not popular. Let's put it that way. Anyway, so just coming back to so today I want to talk about privacy protection by executive action. Now, there has been, I'll tell you what changes. There has been, in the last 2 to 3 years, a significant effort involving the government, civil society, and industry in developing a privacy law or privacy protecting provisions, at least in Indian law. This effort is unique in many ways because for the first time this appears to be a meeting of minds between people who traditionally do not agree a lot. So there appears to be a shared need that between government, civil society and industry to have privacy law, perhaps for different motives nonetheless. And from 2011 the effort has consistently been to develop statutory law. But I want to differ over here and talk about the ease with which it's possible to make privacy laws by executive action. And the reason I want to do it here is because this is a legal audience, so I don't really have to explain basic administrative law issues. If you just move to the next slide. Before that, I just want to place this entire argument in a context. In the 2000s, there has, and perhaps even now, there has been a contest in the Supreme Court and in the higher judiciary, but definitely in the Supreme Court, between the executive and the judiciary for various, the price of the contest has differed from time to time. But what is certain is that when in 2004 the first UPA government came to power, with a pronounced left agenda. That government's agenda immediately clashed with the Supreme Court, which I'm sure you know reflects fairly aspirational middle class values, and there was at that time certainly a clash. And this was felt in a number of judgments. And the court went so far in 2004, December I think, in the case of Shakunanda Sonowal, to strike down a statute, strike down an act of parliament on the ground that it was not efficacious, introducing for the first time in Indian jurisprudence a third ground by which a court could strike down law. It reached a point where every Friday the Godavarman matter, which is the forest bench, would take place, and the central government at that time hired a new additional solicitor general, NUJS, whose only brief, it appeared, was to come to the Supreme Court on Friday and challenge the jurisdiction of the court. And this went on for a while. So the Godavarman matter, and I'm sure all of you know the Godavarman matter, which is the forest bench, the Supreme Court took to itself and through a 4-member committee began deciding what forests were and what activities could be permitted in forests. And as you can imagine, this affected mining, infrastructure, wildlife, national parks, controversial issues such as development in tribal areas, scheduled areas. And into this already controversial debate, we have an ESG who consistently said every Friday, and that prevented the court from working, but consistently saying that the union government had wide and legitimate executive powers through which it could run the country. Now, this was the defense that was consistently raised, and the court went to great extent to try to strike this defense down. But they couldn't do so because of a long history of jurisprudence, where a number of constitutional benches in the past, starting from 1950s, 1951, have consistently upheld the executive power of the central government. There are three kinds of executive powers. There is the wider executive power, which emanates from Article 73 of the Constitution. Article 73 says that the executive power, I'm paraphrasing, the executive power of the Union runs coterminous with the legislative power of Parliament, which is to say that all entries in List 1 of the 7th Schedule lent to the central government power to frame law, not statutory law, but law nonetheless. In Ramjawara Kapoor, which is the Punjab textbooks case in 1955, the court held that even in the absence of controlling legislation, the Union government could frame law. Which is to say that if there has been no statutory law on a certain entry in List 1, it was nevertheless open for the central government to legislate on that area by itself. Now, this is the wider executive power. This position was further clarified in 1982 and 1990. Both of them were mining cases. The second was a mining case, where the court held that even in the presence of controlling legislation, the Union government nonetheless had the executive power to legislate further in that area as long as the Union's executive power did not conflict with the legislation. So therefore, if there is a law regulating surveillance, it will be open, and if there's parliamentary law regulating surveillance, if there was one, it would nonetheless be open for the central government to legislate in this area as long as it did not conflict with the law. So we have two kinds of wider executive powers. In addition, there is a subordinate executive power, which is a factor of delegated legislation. The case law here is pretty straightforward, and this is something that I'm sure all of you have studied in your administrative law class. The basic principle is that you cannot delegate an essential legislative function, which is to say that Parliament cannot delegate to an executive authority the right to make policy. Now, successive judgments following Indre Delhi laws have further, have almost flattened this distinction apart. It is now more or less open for the central government to do anything. There are two kinds of subordinate powers, and this distinction is important. There is the rule-making part, which we are familiar with, but there is also a more interesting subordinate power in the form of orders, usually given under various acts. For example, the Foreigners Act has in Section 3 a clause which allows the central government to frame orders. And using this power, the central government has framed orders that dealt with partition, that dealt with people coming in from Tibet, Sri Lanka, Bangladesh, Burma, Uganda, China, Iran, Iraq, Somalia, Djibouti, Ethiopia, Sudan. It is a vast power. In addition to these two vast powers, there is a directory power of the central government, which extends to the giving of directions to the states. This is almost like an emergent power, so we're not concerned with it. The point I'm trying to make over here is that the Constitution and constitutional case law leaves open to the central government to frame privacy law, we'll come to what privacy is later, to frame laws to govern surveillance, personal data, interceptions and communications in the absence of existing legislation, and even in the presence of existing legislation, as long as it doesn't conflict with the legislation. Can we go to the next slide? Now, before we move further, I just want to point out that there always have been, and they continue to be, large, important, expensive, and pervasive government programs dealing not just with surveillance but a variety of other issues that are implemented solely through the executive power. Currently, the CMS is just one of them. The central monitoring system, or the centralized monitoring system, which is, and there isn't a lot of literature on this topic, so my information may not be correct, but I don't think anyone's is at this point. The CMS, which is comprised of a variety of other efforts, the telephone call interception system, NACRIT, the UID project, all of these are being undertaken in exercise of the Union's executive power. For the UID project, a bill was introduced in Parliament, it went to a standing committee, and as far as I know, it's standing for that. What I want to point out over here is that it is possible for the central government to collect information, store information, surveil, intercept, communicate, we'll come to interception, collect, store and surveil without a law being passed by Parliament. And the reason is the legal arguments I just proposed earlier. Now, as a general rule for executive action and its relationship with the fundamental rights, executive action in furtherance of the wider power, not the subordinate power, the wider power, which is to say that executive action flowing from Article 73 and not that flowing from the rule-making power, from the order-making power, can do anything that Parliament could do, but it cannot violate the fundamental rights. There's a host of case law, I've listed them here, with paragraph numbers for you to check. Next slide. However, for specific rules for Article 21, and I choose Article 21 because this is where the right to privacy is located. It has been discussed in the context of Article 19 as well, but I think now the consensus is that privacy emanates from the right to personal liberty in Article 21. The specific rule in Article 21 starts with Justice Bhairav's dissent in Kharak Singh, which traced some form of privacy from the right to personal liberty, but did not locate it there exactly. In the later case of Gogan versus Madhya Pradesh, the Supreme Court, I think it was a division bench, said that some of the rights of the fundamental rights, but it specifically identified Article 21, could be described as contributing to the right to privacy, but nonetheless subject to a compelling public interest. Both of these dealt with locational privacy. There have been other one-off cases to deal with privacy of communications, which is PUCL in 1996, and NAS Foundation, which is in appeal right now, so cannot be relied upon. The rule in Article 21, as opposed to the general rule that I had just proposed earlier, is that any executive action that denudes the right to personal liberty, which goes from Article 21, requires that the process of that deprivation be just, fair and reasonable. Maneka Gandhi is, although cited very often, is a very confusing case, and it does not appear to be a consensus, except to the extent that, Justice Krishna also did not really agree on reasonability, so we only have just and fair. But nonetheless, you can locate natural justice over there. If this is the case, we then have a situation where the wider executive action, the wider executive power that is available to the central government can be used to frame laws to govern privacy, as long as these laws do not conflict with an existing act of parliament, or if there is an existing act of parliament, as long as there is no existing act of parliament, and if there is one, as long as there doesn't conflict with it. We then come to the issue of how to categorize privacy. Over here, okay, so it's not possible, and I'm not even going to attempt a categorization of privacy. I'm just going to give to you what other people have done. For a good taxonomy of what privacy might entail, have a look at Dan Missalav's article. I apologize, I don't know how to cite the UPenn law review, so I'll just use generic citation. The government's 2011 bill saw privacy in 4 aspects. That's listed on your screen. The collection of personal data for commercial purposes, interception of communications, visual surveillance, and spam, what they call direct marketing, but spam. And if you remove spam, since it does not cause harm, it can be dealt with under tort of nuisance, then the legislative aspects of privacy are just threefold. The collections of data for by the state or by private persons for whatever end, whether it be for commercial ends by private persons, whether it be for governance ends by the state in the case of the IoT project. Interceptions of communications, both voice and data communications, and both data in transit and data at rest. And surveillance, the entire gamut of surveillance. I am just proposing to deal with human surveillance, signals, measurements, financial and geospatial. All of these 3 aspects we have to look at. We have to look to see whether existing parliamentary law covers it. There is no parliamentary law right now that deals generally with collections of data. There might be existing laws that authorize limited collections or large-scale collections for very specific purposes. But as a rule, this field is vacant. There is no controlling law on the subject. It is open to the central government to legislate in this area tonight. For interceptions of communications, we have Section 5(2) of the Telegraph Act and the rules. Now, the rules are a subordinate executive power. to the extent that it would then be open for the central government to frame new orders or rules or by just general notification legislate in this area to the extent that it does not conflict with 5(2) of the Telegraph Act. The issue of what happens when two forms of executive power conflict has not been determined yet by courts. So when the exercise of the wider executive power conflicts with an existing exercise of the subordinate executive power, when rules issued by the central government under authority of Parliament conflicts with the general executive power of the central government, that issue has not yet been decided by the courts. And this is something that we need to look at. We have no laws that govern surveillance generally. As someone was pointing out earlier, our intelligence agencies who conduct most surveillance have not been statutorily created. I understand that there are 26 national security agencies and they meet every Monday in the Home Ministry. These include the two large ones, Intelligence Bureau and RNEW, but as well, in addition, a number of subunits of these agencies, some of which have got independent status now, police intelligence, military intelligence, and a whole variety, entire gamut of intelligence agencies, all of which have not been statutorily created, except the CBI and police intelligence to the extent of the Police Act. So therefore, the proposition I'm making here is that to the limited extent of interception law, which can easily be bypassed because it's one section and mostly by subordinate executive power, it is open for the government in exercise of its wider executive power to frame laws to comprehensively deal with privacy. This will do two things. It will provide an immediate regime of privacy protection, which can be enforced by citizens in courts as long as the law provides for it, and will hold the field until Parliament takes control of this field. Existing executive action does not preclude Parliament from framing new laws in this regard. This has never been the case and will never be the case. This is a broad argument that I'm making, and the last slide I want to come to is which deals with legislative competence. Yeah. The only issue here is one that emanates from Articles 246 to 245 to 247 of the Constitution with legislative competence. Between the entries in list 1 and list 3, it is, I think, wide open to the central government to frame these laws. The Defence of India and post telegraphs, telephones, wireless broadcasting, and any other residual powers all deal with interceptions and surveillance. In addition, personal data can also be dealt with under NT 31 on list 1. List 3 in any case has the general criminal power, criminal law and criminal procedure. The only exception, the only problem that might occur is that public order and police are not state subjects. Is that in the next slide? There's no next slide. Okay, so the only other issue here is that list 2, which is the state list, contains the entries of public order and police. And to the extent that it is open, it is exclusively for the state to legislate in this area, the central government, Parliament and the central government cannot. However, this is also not a black and white area. It is highly contested. In two cases, in Kartar Singh and in QCR, the Supreme Court has held that for elevated threats such as terrorism and surveillance, Parliament can't take control of these fields, and it has happened. The only issue here is whether privacy or matters arising from privacy or matters that deal with privacy, such as surveillance and interception of communications, can be dealt with through an elevated threat to allow the central government to take control of this field and thereby create for all Indians a uniform privacy law without having to go through the long-drawn process of tabling a bill through Parliament, accommodating various concerns, which will dilute the bill and resulting later in what could possibly be compromised legislation. Thank you. This is the limited argument that I wanted to make, and I just wanted to make it here today.
I thank the panelists for their speeches. We now open the floor for some questions. I request questions to be directed to specific members of the panel as opposed to the panel itself. So, if anybody would like some question to ask a question.
Good afternoon. My question is directed to Mr. Acharya. So when we talk about the privacy discourse in India, and so you have to concede that there is a certain extraterritorial aspect that we must also consider. So when we talk about intelligence agencies who are spying on, say, foreign nationals, is this right to privacy supposed to be extended to them? Like recently, the Obama administration spying on their allied countries' citizens had come under heavy criticism by citizens across the world. So is the Indian privacy discourse supposed to import such a factor? Is, for example, Indian customs, they have something called the APIS, or the Advanced